Thank you so much, and thank you for having me. It's nice to be back to present at Wentzville. I think this is the third or fourth time we've done this together now, so it's nice to be here, see some familiar faces, and move from City Hall over here this year, so it's great to check out this facility as well. As you said, my name is Stephen Davis. I'm with the law firm of Carmody McDonald. I'm a member of our condominium and home. Sorry, I'll hold this closer. Thank you. I appreciate you letting me know. I'm a member of our I'm a litigator, and I'm a member of our condominium and homeowner association practice group at the firm. We're a firm of 60 or so lawyers located in Clayton. We're one office. We're serving folks around the St. Louis region. And we represent about 350 or so communities around town now, throughout the metro area. And we've kind of grown this over the years, trying to do these sorts of things, education, just be responsive to our communities. We know that there are a lot of different needs for the community associations we work with, and we like to try to be there as a kind of responsive member of your team to help you with those answers. So we're going to do I'm going to try to be quick, but I want to hear your questions. Please interrupt, raise your hand, and I want to make sure that we're providing that education, and I recognize that people kind of come to the job of being on a board or being a trustee from various levels of experience and knowledge. And so we want to I always start with legal foundations. That's where I'm going to start first, about what is a homeowners association, or we're mostly dealing with homeowner associations, but also condominiums. So people know that, what is it, what isn't it, and answer your questions about that. And then we'll move into some of the topics that were on the agenda tonight, which was meetings, maintenance, and contracting. But I also want to mention the Corporate Transparency Act. I'll talk about that at the end. I'll try to be quick, because it's a new federal law that became effective this year for existing corporations. It's going to have some obligations at the end of the year. So I'll probably go quickly through those slides because I want to get you through the program, and I don't want to hog the time, but I want to make sure we hit on these important topics. So jumping right in, what are homeowner associations legally? So I want to just put all this up here first. They are creatures of statute. That means that we're talking oftentimes about Missouri law. And again, we're here in Wentzville, Missouri, so we're talking about Missouri not homeowner associations. We do also work in Illinois. But we're talking about the Nonprofit Corporation Act, Section 355 of the Missouri statutes. That provides guidance for many of our communities that are nonprofit corporations. For condominiums, do we have anybody here from a condominium tonight? I didn't think so, so we'll skip over that. But there's also, in Missouri, there's no homeowner association act. Actually, the legislature's working on that, and there's through the local community association institute chapter, there is a Missouri legislative action committee that's been working with the legislature on a homeowners association act in Missouri, but we just don't have anything like that here. There's certain statutes that apply for sale signs and campaign signs and solar panels, things like that, but there's not an actual statute that governs that area, unlike what we do have across the river in Illinois. There are also creatures of contract. And so what that means is there's a contract that governs these communities. That's your indenture, your declaration, your CC&R. And that's the contract that everyone as an owner in that subdivision is bound by and is obligated to comply with, because you bought a house, a home in that community. Even if you never saw it, even if you didn't sign it, it runs with the land. The owners are on record notice when they buy their property, right? And I know as trustees you'll often hear, well, I never saw this, or nobody told me about it, or I didn't sign it. Too bad, so sad, right? You bought the home here, it's bound, it's recorded, you got to comply. And it's important that, as trustees, that we know that. What's also important is unrecorded documents. A lot of times we hear from communities, especially newer developed communities, people will say, well, we want to adopt rules and regulations. This is something that's often not recorded, and so owners don't have record notice when they buy their home that exists. And so you have to, as a trustee, you've got to let them know. And a lot of times that means when you're having a sale, it's going through a title company usually, you're providing documents to them, say, here's the documents for our community, include the rules. A lot of communities will have a new homeowner package or packet that you provide, and here's the stuff you should know, and you'd include the rules. And that way, down the road, if you're trying to enforce those rules, we can say, oh yeah, they were provided to them. And it's a good practice, of course, whenever you change them to provide them to everybody again. If it's a nonprofit corporation, and sometimes you're not, a lot of homeowner associations are organized as nonprofit corporations. That means they register with the Secretary of State with a form and set up a nonprofit corporation. You either have annual or every other year filing requirements of who the directors are, who the officers are. Some are trusteeships and have nothing filed with the state. It's a legal distinction, probably doesn't mean a lot to most people, but it is a distinction, and a distinction that matters as far as governing these. But if they are a nonprofit corporation, that means there will be articles of incorporation that are filed with the state. That is something that you need to comply with and be aware of as well. And if you're a nonprofit corporation or some other corporate form with filings with the state of Missouri, then you'll need to pay special attention for the Corporate Transparency Act at the end. And if you're like a lot of people out there that you've got a business or something that's running through an LLC or you own property in an LLC or something like that, you also need to be aware of the Corporate Transparency Act, so we'll talk about that at the end too. I'm going to stop there because that was a lot of legalese at once. Does anybody have any questions about any of that, about just how these are set up and what they mean, what the law is we're looking at? Yes, ma'am.
Do HOAs have a fiduciary obligation to enforce?
We're getting there in just a second. So that's good. Thank you. That's a good segue. Next slide. So we'll get there in just a second. This is what law applies. And so in Missouri, the main distinction is, are you a condo or are you not? Okay, because in Missouri, we've got that condominium act that was on that slide we didn't really go into, but everything else is not governed by that. But we're usually looking at a nonprofit corporation. Where are you also matters, right? We're dealing with Missouri law, but here in Wentzville, we're also looking at municipal ordinance, municipal code, because that's going to impact how things operate as well. So getting those powers and duties and obligations, your governing documents tell us what your board or trustees both have the authority to do and what you're obligated to do, right? And so when you're elected and you're filling this role, you are taking on certain responsibilities under those documents, right? That contract. As a board member, you're elected to fulfill the obligations under that contract, to hold people to it, to make sure that people fulfill their own obligations as owners, as members of the HOA. You also, on the flip side, have certain other obligations that we're going to talk about. And so you want to make sure you're exercising your obligations in a proper manner. And so what do I mean by that? You mentioned the word fiduciary, right? And so as a board, you're taking in money. Some boards have very high expenses, maybe more services, taking a lot of money that they're dealing with. And so we want to make sure that we're using those resources in a good way, in a reasonable way. So sometimes those obligations may butt heads, right? Sometimes the documents may say no fences over 4 feet tall, just an example. Somebody puts a good side out, right? Something like that. But, at the same time, so they did not comply. They're too tall, it's built backwards, whatever it is, right? So as a board, you have an obligation to enforce the documents, that restriction that says you can't build a fence that way. On the other hand, are you going to sue everybody that builds a fence 2 inches too high? Some boards say yes, some boards say no, but you're balancing your obligation on the one hand to enforce the documents, on the other hand, those fiduciary obligations to use the resources of the community in a wise, reasonable way. So we want, yes ma'am?
Does the HOA have the right to put in calming measures on your subdivisions?
Put in what?
What they call calming measures on the street bumps?
Speed bumps?
Yeah.
So it depends, right? And you're going to hear a lot of that. Let's look at the documents. A lot of times streets are dedicated to the municipality, to the public authority, right? And so then the municipality is going to have authority over those sorts of things. And you're going to want to talk with your city representatives in the back about that later. If they're private streets that the HOA has control of, you'd have more of an ability to make those decisions on your own, but you're still going to want to talk with fire, et cetera, about what obligations and requirements they're going to have before you make any changes there. Yes, sir.
What are the options a trustee has to enforce the rules? You said sue. What are the other options?
That's a good question. So in case everyone didn't hear, I should probably repeat some of these questions. What are the options that trustees have to enforce the documents? It really, again, like I just said, it's going to depend on what your documents provide. And the reason I say that is because some of these contracts, some declarations or indentures are going to say you have the power to levy fines. You have the power to take away somebody's right to use recreational amenities like a pool or something. Or they can't serve on the board, or they can't vote. Some communities have that. If it's not in the documents for an HOA, you can't do it. So a lot of times what we'll see boards try to do is put a rule in place to be able to levy fines. unless that contract, the declaration says you have the ability to put fines in place, you really shouldn't be going down that road, and you'd have a hard time having a lawyer go down the road and properly collect them later. Yes, sir?
What if it's the opposite of what you're talking about? What if the board is not doing their job and following the contract?
So the board has an obligation to follow the contract. The question is, what if the board's not? Well, you know, the board, a lot of times there's some level of interpretation there. Are they doing it, are they not? It's black and white, but are they doing it to some degree but not doing it all the way? If a board is not enforcing the documents correctly, you know, you have a right to, like the rest of, you know, anybody that lives in the subdivision, to run for the board, replace them. Board members can often be removed from office and replaced. Boards, associations can also be sued, and you'll hear about insurance in a little bit, but boards can be sued for their failure to fulfill their obligations under the contract. Usually that's why we prefer you to be set up as a nonprofit corporation instead of a trusteeship. Members of a board of trustees are sued in their own capacity as individuals, acting in the capacity as a trustee. Your name will be on the lawsuit, where when you sue an HOA, the association, the nonprofit corporation is the party that's sued. But either way, if you're a board member or a trustee, you want to make sure that you're talking with an insurance professional to make sure that you have proper insurance in place to protect you if you're sued for doing what's obviously a very high-paid job. Right? Yes, sir.
So one more question.
Yeah.
So if the indentures for the HOA do not state how, you know, that you can fine or anything like you said, don't do it, what are the options to get the indentures updated?
Right, so the question is, well, if it doesn't say you can fine or whatever, you know, other enforcement mechanisms, what do? Usually you're gonna amend the documents. And most of the time, and almost every time, I've seen it where it doesn't happen, but you're gonna have a provision in there that allows the owners to vote on and approve an amendment that would then be recorded in the county records. And so usually that's gonna be 2/3, sometimes it's lower, sometimes it's higher, depends again on that contract. But you would, you know, have a lawyer prepare an amendment. Something like adding a fine, the ability of fine is not really that complicated. But usually what we would do is we put together an amendment that allows you to levy fines and then adopt rules on how it's gonna be. Because we wanna give you the flexibility, you know, you don't wanna put in the recorded document that has to be amended that fines are gonna be, you know, $25 in perpetuity. You know, sometimes, you know, we know inflation changes things, right? Yes, ma'am.
So do these amendments, our bylaws and covenants are outdated significantly in that, like, you know, it says you can have one animal, farm animal per acre. Well, it's one animal per 3 acres in St. Charles. So there's some discrepancies there. Would all of these amendments have to, would you do all the amendments separately, or would you just redo the whole covenant?
Sure, so there are a couple of questions that are asked. Do you do one amendment at a time or do it all, or if it's outdated in some ways? And also about county law or ordinances versus what the governing documents say. If your governing documents in any way violate, you know, state, federal, local law, then that restriction is going to be invalid. There's a bill pending, I don't know if the veto happened or not, but there's a bill pending in Jefferson City dealing with chickens, raising chickens. And so a lot of governing documents restrict the ability for homeowners to have animals aside from, you know, typical pets at their home. If the legislature changes the law and says, no, you can have this, then that changes the law, right? They can make rules that would make those restrictions invalid. As far as amendments, it really depends, you know, what the need is, what owners are going to approve. It's often a high percentage to pass it, so we want to make sure we're being reasonable. But, you know, that's something that we can talk about maybe afterwards or something like that. Yes, ma'am. And then I'm going to move on because I don't want to get stuck right at the beginning.
Two questions.
Yes, ma'am.
So we have a lake and it's gated.
Okay.
So if we have people who keep violating, I don't think it's in our bylaws. Can we restrict them from going to the lake if
So
it's not in our
They've got an
covenants or
amenity
bylaws?
lake in their community, and they want to see, could they restrict people from using the amenity lake? And you said it has a gate around it, so you could keep people out.
Right.
If your documents were amended to allow you to take away that right to use that amenity, like a pool or anything else, you could take away that right until they, you know, are, you know.
So we have the fines in our, but I don't think that that's in there. for
Something to
the-
check for, yeah.
Yeah, so that would have to be
It
in
would need to
there
be in there, right.
to take somebody's
It would-
rights away
Right,
from.
when you buy a home in a community with certain amenities, you then have a right to use those amenities. We can only take away those rights, or we can only fine somebody for violations if the documents give you as a board member or trustee the power to do so.
Okay, and my second question, somebody was talking in my board meeting about a law in 1985 about you have to have a certain percentage, that it couldn't be just a board controls any and everything that happens. That
Why don't we
they-
talk about talk about a specific statute or something from 1985? Well, let's talk about afterwards about that.
Okay.
For any questions we don't get to, I'm happy to give you my card, we can talk later. And I'm gonna, if it's all right, since I was saying, let's take that one more, it's fine, go ahead.
Well, I think you might have answered it, but
Okay.
whose responsibilities in the HOA when property is sold to advise them if there is an HOA in the community?
Sure, so who would tell somebody there's an HOA? The indenture declaration CC&R is recorded, so when you buy property, you should get the recorded documents, and it's your obligation as a buyer to get them. A title company will often pull that as part of the sale and provide it to you, but it's really, you're buying land, you have an obligation to run title and to figure out what's encumbering it. Good. Yep. All right, moving right along. Look to the documents, make sure you have a complete copy. More often than you would think, we find communities think they have everything, but they don't. So let's make sure we do that. I'm gonna move along. This was a question before about duties. So most members are members of nonprofit boards of directors. As a board member or even as a trustee, you have certain duties to the membership of that community. The first one I talk about is the duty of care. That means to act as a reasonably prudent board member would. What would be reasonable for a board member in your situation to do, right? And a lot of time that means relying on people who are experts. For example, you've got some sort of situation that calls for, you got a retaining wall, maybe it's fallen over, you're not sure what's going on. You get an engineer or a soils expert of some kind that can advise you on how to handle it. When a board of directors follows the advice of an expert that's hired to review something, then you're providing yourself protection under the law. Where if you just act on your own and do whatever you want, make a guess, maybe that's not what a reasonable person would do. You don't have any training as an engineer, why are you making engineering decisions? You have a duty of loyalty. What is that? That was a little bit more obvious, but a board member's brother has a lawn care company. Well, it's okay to hire the board member's brother who has a lawn care company, but that board member should be recusing themselves from the meeting. Maybe that brother's offering us a great deal for good service because of the relationship. That's okay. But, obviously you want to have independent bids and compare it and make sure that board member with an interest potentially in the outcome is not part of the decision making, and you should note that in your minutes. When you exercise your duty of care and duty of loyalty properly, that's what's protecting you. It's called the business judgment rule. That would be something when a board member is, again, acting within the scope of that authority and within their powers and exercising reasonable judgment, not, having conflicts of interest, you're going to have certain protections under the law. And we'll talk about insurance more later, so I'm going to skip over that, but that directors and officers liability insurance offers protection for those acts that you take as a board member acting within the scope of your authority. Ultra-virus acts is a nice Latin phrase for meaning you better act within the scope, because if you act outside the scope of your authority, meaning beyond the powers granted to you by those governing documents, you may not have insurance coverage to protect you. So you want to enforce your governing documents, enforce it equally against all others as it's written. Don't go beyond that. Don't treat some people differently than others. Treat everybody the same, and you're going to, get along just fine. Sure, right. I'm summarizing here. So the next topic on our agenda was meetings. We got the legal foundations. Please continue to interrupt meetings. A lot of this is just to have a lot of information. I see people taking pictures. The slides were provided to Wentzville. I'm sure we'll be able to get you a copy at the end. If you'd like to make sure you get a copy, I'm happy to give you my card too. We'll get you a copy. I don't want you to have to take pictures of each slide as I put it up. Your community, those governing documents are going to require you by law to have certain meetings. Usually you're talking an annual meeting, but there's also other types: regular meetings, special meetings, court order meetings, even actions outside of a meeting. Elections often happen at an annual meeting. Most communities are going to be electing somebody every year. Usually you'll see like a 3-year rotation of 3 people where someone's up each year, a 3-year term, but every community is different. Removal of board members can happen at a meeting too, at a special meeting usually. Budgets are often approved or financials reviewed at certain meetings as well. Just check the documents. That's for owner meetings. There's also board meetings. The difference between owner meetings and board meetings is owner meetings can occur in person or by proxy. Meaning you show up in person to the owner meeting, the annual meeting, and you count that you're there. Or you can't make it, so you give somebody else who's going to be there a proxy to act on your behalf at the meeting. That's what's called a general proxy. We could talk more in detail, but make sure that proxies happen because that's going to help the board meet their quorum requirements for that annual meeting or for other meetings of the association as a whole. Yes, sir.
How do you handle, right now our HOA is out for open nominations.
For an election.
3 weeks to send their names in or nominate a neighbor. Right now I have not received any nominations back, so what happens then?
Right.
That closes and
Sure.
the president's already said she doesn't want to rerun again.
How do you get people to be on the board, right? Right?
We're only
Good. We got
25
great volunteers here. How do we get more people to volunteer? A lot of ways to answer that question. The most direct way is to encourage them, right? How do you encourage them? You create committees to get people involved because that's a training ground to think, okay, I can step up and take more responsibility now. You follow the advice I'm going to have for efficient and productive meetings down the way so people know it's going to be an hour and a half. I'm meeting this often. It doesn't go to these 4-hour crazy sessions, right? You go door to door for proxies and for nominations to say, hey, we really would like to get you involved. We need your help. It's your turn even, right? I mean, going door to door is going to help you get there because that's how this happens, right? You're the smallest building block, I see it, of our democracy. And so you're really choosing as a neighborhood how you want to live, and it involves some participation.
But what would happen then?
And what happens if nobody?
You only got a 1-year term.
Nobody.
So nobody will do it, right? Hopefully, usually you don't have to get nominations for most of these documents in advance. So usually you call for nominations on the floor and say, hey, you showed up tonight, we got quorum, one of you needs to do it. What could happen if nobody will do it and there's no board members left, right? Then you'd have a situation where it's possible that somebody would essentially be appointed by a court to serve as the board for you, and your assessments would go up because you'd be paying someone to be a board member.
And our documents do say that the city of Wentzville could appoint.
And oftentimes the documents will say that the city, in this case Wentzville, could appoint someone, but again, you'd be paying them to be the board because nobody wants to do it as a volunteer. And hopefully, actually, yeah, where I live, we got a letter a couple of years ago saying something like that, similarly, where nobody wanted to do it. So, and then there were volunteers and it worked out. And they said, if nobody volunteers, then we're gonna have to talk to the city and they'll, hire someone and you're gonna have to pay for it. So that'll motivate people. Yes, ma'am.
Action without meeting, is that a secret meeting?
Action without a meeting, is that a secret meeting? No. So what that provides for is boards, well, in this case, an owner meeting, certain actions in the Nonprofit Act, and again, assuming you're a nonprofit corporation where this applies, we're talking very generally tonight, but allows for actions to occur by written ballot outside of a meeting that could otherwise occur at a meeting. Oftentimes we're doing amendments that way. Sometimes we're approving budgets that way. Sometimes we do elections that way. People won't show up. There are ways to do that for certain communities where you actually send out a notice to everybody, you tell them what the quorum is, and then they have a certain period of time to return their ballots. So everybody receives notice, because if it's put in the mail, that's deemed as notice, even though we know mail sometimes doesn't get there. But you make sure you mail it, because that's a safe harbor under the law. When you put it in the mailbox, that counts as it went. Yes, ma'am.
How do you deal with rental properties in your HOA?
Let's talk about rental properties off this afterwards, because we'll get down a whole tangent there. But there are ways to restrict and limit leasing, rentals, ways to deal with it.
Not so much leasing and rental, but they're voting, like how are they?
Voting is done by owners. Renters typically cannot vote.
No, the owner of the rental property.
How do they?
Yeah.
If you own rental property and you own a lot of units in a community, a lot of homes, you have that many more votes. When you own each ownership unit comes with a voting interest. But we can talk more about that. So unlike owner meetings that occur in person or by proxy, board meetings can occur anytime the board members can all simultaneously hear each other. Phone call, Zoom, email, no, but they can occur they can also do written consents outside of the meeting as well. So general requirements, send out notice, when's it going to be, make sure you do it in the right time. You know, are you sending it the right way? Make sure you list the agenda items. What are the action items that we're voting on? That needs to be in the meeting notice and tell people, here's what's on the agenda. What is your quorum? How are you gonna meet it? Are you gonna go around, you send out a proxy notice, that's great, but if you don't get enough back and you can't get a quorum, you can't conduct business. So go around and collect those. Door to door if you have to. You need to take minutes. We're gonna talk about what should be in minutes in a second, because I've seen too often where minutes include way more than they should, right? We don't want a play-by-play, blow-by-blow of who said what to who at the meeting. We don't want, I've seen in minutes, you laugh, but I've seen in minutes when people make notes about another neighbor that they don't really like too much in the minutes, and then the neighbor sues about something else, and those minutes are all discoverable. And now we're dealing with in court. So, you know, if you're a board member, and most of you are, don't put in the minutes, don't put in text, don't put anything in writing that you wouldn't want read in court one day, okay? Meeting expectations, time, the content, who can vote, how do you figure out who's gonna vote, and what's the procedure you use? How do you know, I've seen boards that wanna have a police officer come to a meeting because we know of an issue. You know, in this day and age, I'd rather get out in front of it and make sure we got an officer there if we need one, and we're being mindful of that. You know, how are we gonna handle certain situations? These are things you can talk about ahead of time. And your governing documents and the relevant statutes are gonna help with that. Here's those tips. This will be in the slides, but you know, make sure that you're kind of thinking about things ahead of time. You know, we want to, by having well-run, productive meetings, we're going to get more business done. We're going to get answers to things that we need to run the community, and we're going to encourage more people to want to be on the board because they're like, you know what, this is a well-run organization. I didn't just spend 5 hours here tonight. You're not really getting anything done. One of the things that often derails meetings is allowing the owners at a board meeting or at an owner meeting to comment on everything. That's not how it works. That's not what it's there for. You should have a discussion period. Usually what most communities do, well, everybody can have their 2 or 3 minutes at the end. They can talk at the end during an open forum, raise your hand or whatever it is, sign up, you get your 2 minutes. And again, the board doesn't feel like they should have to feel like they have to answer every question. Because if one board member answers, they may not be able to speak for the whole board unless you've met together and talked about what the answer is going to be first. So it's okay to say thank you for your question, we'll get back to you. Yes, ma'am.
Are the HOA board members required to send you the minutes of the meeting if you're not able to?
I'm just looking at the time. Are you required to send the minutes out? The minutes, once they're approved at the next meeting, they should be distributed to the owners or posted online in a way that you can access them. I don't know what time to start, but I'm just trying to pick up the speed a little bit. So the minutes should record the actions. They should not record verbatim. Here's kind of a list of things that they should kind of say, but generally you're talking action items. There was a motion made for something, there was a vote taken, here's the result, right? Yes, sir.
How do you feel about preventing a member of the association from attending a board meeting? The best practice is board meetings should be open to all of the membership. That's the best practice. I wouldn't get into the business of excluding people from board meetings, and certainly not from owner meetings. Now, some communities have language in their documents about closing the meeting. Some have language that tracks the Missouri Sunshine Act in some ways, where governments are allowed to close meetings for certain topics, legal, hiring, firing, contracts, that sort of thing. You're not a governmental entity as a board. You don't fall under the Sunshine Act, so there's no obligation to follow that. There's really no reason to have a closed meeting unless your documents provide a reason that you should do it. Next subject on the list was property maintenance. So just some common questions in the way that we approach. Yes, ma'am.
I'm sorry, quick question on the previous.
Yeah.
Is there a time limit between the meeting and the meeting minutes distribution?
So when should minutes be distributed? No, there's not any, unless the documents provide some of the governing documents about when minutes should be distributed, no. Usually what would happen is the secretary after the meeting prepares the minutes, they're circulated at the next meeting, and at the beginning of the next meeting, the board would approve or edit and change the minutes however they need to be to
What
reflect.
if you're meeting only once a year?
So, right, if you're meeting once a year, it might not happen until the next year.
Okay, so there's no.
Right, unless your documents say otherwise. So when we deal with property maintenance questions, usually the question we're asking, and every community is a little bit different, but a lot of times with single family homes, it's easier. But sometimes we've got, single family homes where the association still maintains the exterior and has some certain obligations there.
But often we're talking about what is the element? Is it something that's common to the community, or is it something on the owner? Who pays for it? Or sorry, who maintains that item, then who pays for it? And sometimes the association might maintain something, but the person who benefits from it directly might pay for it. Is the need arising out of an insurable loss or an occurrence under your insurance policy where the association's insured for it and you can get that covered that way? And then the fun question with all the hailstorms we've had lately is is there a deductible and can it be charged back to certain owners in that way? And again, a lot of this I can't go into more detail because it changes based on the community, but architectural control. A lot of communities will have architectural control where an owner wants to put in some sort of change or improvement to the property and it's got to go to the board. A lot of times those documents will say, hey, if you don't get back to us in 30 days, 60 days, 90 days, it's automatically deemed approved, so make sure you're aware of that. And it's okay to say that this would be approved, but you need to provide us X, Y, and Z first. All of those things are acceptable. I'm dealing with one where the document said, yeah, you can put in a pool, but you can't change the drainage or affected that in some way into the ponds that the community has a retention basin. Well, that was done 4 years ago and is now helping us today. And I'm sorry, I realize I stopped holding the mic close. I apologize. So the other thing I like to bring up for maintenance is transition and reserve studies. Transition studies can be important, especially for newly developed communities. That's a study by an engineer of common element property, so things that are common to the community, to say, was it completed correctly? Is everything in line and in order? So we're not going to have an expense in the near future that we was unanticipated. A reserve study is a study that's done often later to say, hey, we want to plan our reserves out when we're doing our assessments now, because we all know assessments when you first move into a place may be artificially lower to help sales, and that's okay. But so how do we, what do our assessments need to be so we have enough in reserve so we can take care of those items that are eventually coming down the road so we don't have a special assessment or something at that time?
Sir,
Yes, sir.
is there any requirement from the state or the city, the county that says this facility or this community has to have a reserve? Do all communities have to have a reserve?
Best practices would dictate that you have reserves. I'm not aware of any statutory requirement here in Missouri, generally, that would require a reserve. After what happened with that condo in Surfside, Florida, I know the state of Florida has reserve requirements, but that doesn't exist here. But best practices would dictate that you have some reserve, just like you would in your, you'd want to have in your private life, you want to have a rainy day fund or whatever emergencies happen, things happen. Your HOA needs that too. But yes, sir.
Real quick, I've heard from several insurance agents that recommend the loss assessment rider on an HO6 to cover the deductibles in case of a hail or windstorm, where the HOA would actually bill the homeowner for the appropriated loss, and they turn that in on the loss assessment.
Right, so this is more specific to insurance claims. I brought it up, so that's my fault.
Okay.
But you're right. We deal with a lot of hail in Missouri. We just know that we do, right? For years, communities essentially use that as a way to get new roofs. We know it's going to happen in the next 20, 30 years, so we got new roofs that way, and now insurance rates are climbing through the roof. That's part of it. A lot of other factors involved. But to answer your question, if you've got an HOA, we'll talk about this more maybe, but if you've got an HOA that is responsible for insuring the roofs, as some are, right? Sometimes it's on the owner. But if the HOA insures the roofs, there's a hailstorm, you're usually now going to have a 1%, 2%, 3% deductible on that. A lot of times the community's documents will allow you to then assess that deductible back to the owners. And so what that means is that for a much smaller deductible, they're going to get their share of that larger deductible, which will go towards the HOA being able to replace the roofs. And now sometimes that will apply equally, sometimes it will apply based upon building value in the insurance policy, but that's more specific.
But it's in play as far as you know.
It depends on, that happens often. It depends on the community and their documents. That's a lot of,
Okay.
you're going to hear that, you've heard that from me a lot. Yeah.
So, if I could just say one thing. A lot of times if all of the buildings and units are damaged in the association, that wind and hail deductible is going to be in the millions of dollars nowadays.
Right.
That's what they are. And so if you don't have a way of collecting that from owners, you guys are in trouble, because I don't think you have millions of dollars sitting in your bank account.
Right, you'd be doing a special assessment to get the money, which may still get
Which
to
would
be,
also be loss assessment.
which would also hopefully get to be applied back to those owners' policies. But
Right.
yeah, I mean, you want to go, when you're working with an insurance broker, like we have here tonight, someone who works in the industry, who understands how HOAs work, they're going to, one, be able to help make sure that your association has proper insurance in place, and they're, two, going to be able to make sure that they can give advice that you can send out to your owners to make sure that they have the proper insurance.
Right. Thank you.
Sure. Moving quickly, I think that's why you're up here, yeah? All right, sorry. Contractors and contracting. Review contracts before you sign them. If it's a big dollar contract or a vendor you're not familiar with, ask an attorney to review your contract. It shouldn't take a lot of time, but obviously we all know that when someone gives you a contract, they're looking out for them, right? So we want to make sure that that contract is fair and protects you. Termination clauses I see as particularly challenging. Attorney's fees clauses that let them collect but not you. We're not California where those clauses get turned both ways automatically, so you got to make sure that you're protected. If there's insurance involved, have your insurance broker look. Is this enough coverage to protect you in the event that something goes wrong? Okay, and I'm going to just tell you this. I'm not going to show the slides, but we'll share them later, right? Corporate Transparency Act is a brand new law that just took effect this year. What that means is it's a, it says up there, but it's to stop bad actors. We know that LLCs get used as shell companies to hide things. What it says is anything that's set up through a Secretary of State's office, like a nonprofit corporation, which many communities are, you've then got to file with FinCEN. And you have to file with FinCEN every time that there's a change in the board or a change in the supporting documents that are filed by those people who are filing. And so what that means, just to go quickly, is it's for reporting companies, so the HOA has to report the beneficial owners and the person who files it, like an attorney like me, when we do it, or my paralegal, we have to report ourselves too. And so that means the executive officers, all the board members, all the officers, anybody who owns 25% or more, and then and this is all the information you got to report. So the thing that's really bothering a lot of board members is you've got to give your driver's license or your passport photo. We've got to actually have a picture of that for the filing. I've got to give mine too when I file for people. When my wife's LLC files, I'll be doing that also. And that's so that the government now knows who's behind all those LLCs, who the people are, the beneficial owners of those entities. So we're going to need all that information, and it's important to get ahead of that, right? Because the filing deadlines are coming up. For existing companies, if you're formed before January 1st of this year, it's by the end of the year. And so this is going to be a mad rush at the end of the year to get this together, and the filing actually occurs, like I said, every time. If you use a driver's license, when it changes, if your driver's license expires, we got to file again. And so yeah, you want to plan ahead. You want to make sure that you gather that information, that your board members, that your candidates know they're going to have to do it, because it's a requirement. It's a legal requirement that we file these things, and we do it ahead of time. Can you do it on your own?
Congress or executive order?
Sorry?
Was this passed by Congress?
Congress.
It was.
Yes, this is Congress. Now, the Community Association Institute is working very hard to lobby Congress to get an exception for homeowner association. That hasn't happened yet. There's a lot of different exceptions, as you might expect in a bill out of Congress, but that's where we are. So you want to do that. Otherwise, there's penalties. There's civil and criminal penalties for failing to file. I'm saying this all very quickly, but if you've got any sort of entity, nonprofit corporation, LLC, make sure you talk to a community association attorney or a corporate attorney, or go online and check Google Corporate Transparency Act. There's a lot out there, so you know what you need to do.
What would be the typical cost for an attorney to do all that paperwork?
It depends how many board members, how officers you have. But once we get these going, and once we've done it for you the first year, it's going to go pretty quickly after that, because the company will already be taken care of. Our information's in. We're going to have paralegals, multiple paralegals running these things at the end of the year, because we know in advance it's going to be crazy. Yes, ma'am.
May we get a copy of all your slides?
Yes.
After,
Yes,
because I
you may.
can't take notes.
You may have a copy of the slides.
I'm a
Yes,
little
ma'am.
slow.
That's okay. I went very fast, and I'm sorry. Yes, ma'am.
That's all right.
If the HOA is a nonprofit, why is it equated to LLC?
No, I'm not equating it to an LLC. It's for the Corporate Transparency Act requires any entity that registers with the secretaries of that state that they create a corporate form of any kind. So LLC and nonprofit corporation were the examples I gave, but any sort of company registration.
Thank you.
Yes, ma'am.
How far ahead can you file it?
I believe you can file it now, but if your board is going to have an election before the end of the year, or somebody might resign or move or whatever, we don't want to have to double this up. Or somebody's driver's license expires, right?
Got
That happens too.
it.
Yes, sir.
Got one.
And then I'll pass it back.
What's the definition of a condominium, or what makes a,
What makes a condo a condo?
yeah,
Usually it's going to say condo in there, and it's going to in the declaration, and it's going to say that it's been submitted to Missouri's Uniform Condominium Act or Condominium Property Act. But if you're with a condo, I nobody raised their hand before, so I didn't talk about condos. But if you've got questions for that about those, we're happy to talk about it too. Sorry for going so fast. Thank you so much for having me. Happy to get more questions.